Any type of civil law case would be started by the parties who have been injured. So when we looked at criminal law, we saw that it was the state who normally starts legal proceedings on behalf of the injured party. But with civil law, we see that it is the individual who has suffered the injury who actually starts legal proceedings. And that party is referred to in civil law as the claimant. And the party against whom the case has been brought is referred to as the defendant. So if the Richards decided to start a case against the factory, then the Richards would be the claimant and the factory would be the defendant. In English law, there are separate courts for civil law cases and for criminal law cases. Now, in most circumstances, cases will probably start in one of the many county courts in England and Wales or in the High Court. In civil law, the burden of proof lies with the party who started the case, the claimant. The claimant has a responsibility to convince the court that their case or their argument is more likely to be true than the other party's argument. So in criminal law, we saw that there was a very high standard of proof, and that standard of proof was beyond reasonable doubt. In criminal law cases, the prosecutor has this heavy burden to leave the court with no doubt that the accused is guilty of the crime that they say they are guilty of. However, in civil law, the standard of proof is a lot lower. The claimant does not have this heavy burden to convince the court to have no doubt as to whether or not the defendant is guilty. Instead, the claimant has the responsibility to convince the court that they are more likely to be true or more likely to be accurate than the defendant. So in civil law, we say that the standard of proof is not beyond reasonable doubt, but in civil law, the standard of proof is balance of probabilities. The court will weigh up the two probabilities, the two likelihoods, and see which one is more likely to be true. At the end of a civil law case, if a defendant is found liable, they may be asked to pay compensation to the other party. In some cases, depending on the area of law that we're speaking about, there are other outcomes possible. For example, in contract law, the person who is found liable or the party who is found liable may be asked to pay money to the other party, or they may be asked to complete a job that they were contracted to do but had not yet done under the contract.